Let's say good morning. Today we have the pleasure of hosting Tsachi Keren-Paz. He's professor of private law at the University of Sheffield and also a very good friend here of many of us in Girona. He's his fourth time here. He's been in several workshops, maybe more than a decade before. And now he's back. He has written a lot, and probably he's the scholar that made the deepest effort to show, or the most important effort to show how private law can have detrimental effects on social equality, but also how private law can solve those inequalities also. In this way, his work is very innovative always, and is very very practical. He assumes private law as part of the public policy. That is also a view that we share here in Girona. He has written 3 books. The first I read is Tort Law, Egalitarianism and Distributive Justice, which is also translated in the Martial Pons collection. And this is like the general framework of all his work. But later, he opened new areas of research like sex trafficking. And in his book in 2013, it was in Routledge, published in Routledge, he argued for the liability of traffickers, the state, so far so good, but also clients for generating the demand, for contributing to the demand of sex trafficking. Sexual exploitation. This is also something radical in a way. He acknowledged that in a sense that it required a lot of argumentation in doctrinal terms, how you can fit this kind of contribution, very seemingly slight contribution to generate the demand. And today he's going to speak about digital privacy in his last book, Egalitarian Digital Privacy. Here he argues for the liability of those who host non-consensual intimate images, but also those who disseminate them, so far so good again, but also for those who view. And even if they run or they find these images by accident, there are some qualifications he will explain, but in principle there is liability for viewers in general, which is also something very interesting to see how you can make the argument within the framework of traditional private law, with some adjustments here and there, but without changing tort law in something that you wouldn't recognize as tort law. Okay, enough with the presentation. Thank you, Tsachi, for being here. You know that the usual formula I explained to you for is 40 minutes for the presentation, more or less, and then we will open a debate. Thank you.
Well, thank you, Diego, for inviting me and for the generous presentation. It's always a pleasure to be here. As Diego mentioned, it's my 4th time here. I regret to inform you that I haven't made progress in my Spanish since the last time, so I can't even greet you in Spanish, let alone deliver the talk, so apologies for that. And as Diego mentioned, you probably captured that I don't shy away from controversial arguments. So here I will present in a sense, the latest one. So, in terms of the preliminaries, a few things about the project. It was supported by a Livium Fellowship that I secured in 2016. The book was out with Bristol University Press at April this year. And as you know, it is a lively topical issue. A few days ago I've just seen that here in Spain, some of the youth players of Real Madrid are suspected that they shared some intimate images. So in this sense, this has been going on, and the legal responses have been going, for quite a while. And I guess what I'm try to do in the book is to take the debate further, not only about the liability of those who uploaded or disseminated, but to see whether also internet intermediaries, mainly hosts, should be civilly liable for hosting non-consensual intimate images, and whether viewers should be liable for merely viewing these images without doing anything else. And my answers, as I think Diego hinted, he ruined the punchline that both hosts and viewers should be liable, and that the liability should be strict. A word about methods. The methodology that I use in the book is both relying on first principles, at least as understood in the common law, private law world, analogies and private law theory to defend the claim that hosting and viewing non-consensual intimate images should and could lead to liability for breach of privacy, and engaging in policy analysis in order to justify this liability and curb it so it would not necessarily be applicable to other cases of rights violation. And I think that the book covers quite a lot of ground. In the introduction, I was trying to highlight the hoped-for contributions that I have, both in terms of policy, in terms of the private law theory, and in terms of doctrine. But for current purposes, I would like first to present what I see is perhaps the 7 main points or arguments in the book, and later on I will move to a few other things. Some of them are mentioned here, some of them are others that I thought that might be of interest. So the first point, the first argument is that functionally hosting non-consensual intimate images is equivalent to selling stolen property and viewing them to buying stolen property. It does not make sense that the legal system would afford me better rights against those who sell and buy my stolen car compared to those who sell and buy my stolen intimate images. This conclusion could be held whether or not one views private information as alienable or not. According to what I call the inalienability paradox, it does not make sense to protect inalienable rights from unauthorized intervention by third parties to a lesser extent compared to how property is protected. So at least, as long as liability under the tort of conversion, at common law, is strict, so should be liability for hosting and viewing unauthorized intimate images. But in fact, we have stronger reasons to protect the claimant from undermining their control over intimate images than their control over personal property. So even if strict liability for conversion is too harsh, this is not the case for strict liability for hosting and viewing non-consensual intimate images. Definitely, there are strong policy reasons to hold hosts, platforms, strictly liable for non-consensual intimate images as all other merchants. Second, doctrinally, there is recent support for classifying misuse of private information as an intentional tort for which liability is strict. So in England, the case of Lloyd and Google, in the US, Powerline in the US, I'll talk about it a bit more later, and for treating each viewing as a separate intrusion for which there should be liability. So in England, the case of Douglas and Hello, number 3, and Gulati and MGN, and in the US, intrusion upon seclusion, and the case of Powerline and US. Third point, similarly to the way child pornography is regulated, there should be a distinction between active and passive viewers. So a viewer who receives an unsolicited intimate image and promptly deletes it would not be liable even if the image was non-consensual. More generally, at the level of policy, there is an unjustifiable gap between the way child pornography and other cases of non-consensual and intimate images are regulated. Once child pornography is understood to be a subcategory of non-consensual intimate images, albeit an extreme one, the regulatory gap becomes untenable. Both phenomena are instances of not only breach of privacy, but also of sexual abuse. They are on the spectrum. Fourth, due to the overdetermined nature of causation to the harm from viewing non-consensual intimate images, the liability of each viewer should be to a significant amount, but not to the entire damage from the breach of privacy. This too helps keeping liability for viewing in check. Liability of hosts should be to the entire damage. There is a good argument for the proposition that even if host liability remains limited to failing to remove expeditiously the image post-notice, the notice and takedown out of the ECD, in cases of such failure, liability should be for the entire damage, including the pre-breach period, as the damage is indivisible. Fifth, from a regulatory perspective, platforms should be subject to an upload filtering obligation, backed by strict liability for damage from any non-consensual intimate image appearing on the platform. The ECD's horizontal approach should be rejected, and at the same time, the stronger protection that owners of copyright have against hosts in comparison to the rights of victims of breach of privacy, both in the US and in Europe, should be reversed. I call this the inverted hierarchy and call for what I call NCII, non-consensual intimate images, exceptionalism. The harm from non-consensual intimate images is irreparable, all-encompassing, lasting, systemic, gendered, and on the spectrum of sexual abuse. And monitoring is feasible and has low cost in terms of chilling effects of speech and economically. The reverse is true with respect to copyright and to a lesser extent with respect to defamation. In this regard, the availability of interim injunctions for breach of privacy as opposed to their unavailability in cases of defamation should be translated to the way intermediaries are regulated. Intermediaries should filter content threatening sexual privacy, i.e. intimate images not verified as authorized, but should be under no equivalent obligation to filter potentially defamatory material. To the same extent that my access to my bank or to my employer services online depend on verification of identity, so should the posting of intimate images depend on identified proof of consent of those depicted in the intimate image. 6, contrary to the policy direction of travel at both the EU and the UK, platforms' obligations should not be based on their size or means. In terms of principle, since they actively contribute to the undermining of the right and do so for profit, the logic behind taking into account financial means in terms of delineating the scope of affirmative duties is inapplicable. Moreover, unlike in cases of breach of copyright, the damage to the claimant is not likely to be linear with the number of viewers. As long as those who are likely to recognize the claimant are the likely users of the platform, the harm is significant, so smaller platforms should be subject to the same obligations as bigger ones. Any anti-competitive effect is far outweighed by the injustice to the claimant if strict liability be denied. More generally, the research highlights the need to take into account the fact that the harm from breach of privacy is disproportionately caused by those who are likely to know the victim. Finally, misuse of private information should compensate for the direct consequences of the breach of privacy, even if unforeseeable, at least if there is an intention to harm. It should also compensate for the reputational losses ensuing from the breach of privacy. While less relevant to non-consensual intimate images, liability could be both for the mere undermining of control over the private information and for the consequences of the breach of privacy. Similar to what was decided in Gulati, and similar to the possibility in libel law to award special damages in addition to liability at large. So these are the main arguments. And now I would like to speak about few specific points. So I mentioned earlier the NCII Exceptionalism. I know that since the harm is exceptional, so the response should also be exceptional. So we should depart from the horizontal approach of the ECD that says, regardless of what is the right that is being undermined, so the response or the obligations of the platforms are the same. So, in chapter 6, I have a discussion first. I'm explaining why the harm is so exceptional, and I try to summarize it in the presentation earlier. And then I bring both, from a bit of regulatory theory, working the work of building on the work of Gregory Keating, but also on private law theory to explain the normative relevance of the exceptionalism. So I would like to say a few words about the contribution of private law theory to this idea of NCII exceptionalism. So the first point is the familiar distinction between primary and secondary duties with relevance to tort law. So the primary duty is not to undermine the right. And then if this is breached, there's a secondary duty to remedy. And Gregory Keating and many others argue sensibly that it's better not to prevent the undermining of the right rather than just to remedy if it happened. And obviously, if we accept that the principle or the ideal of full compensation is not achievable, so obviously it becomes even more important practically to prevent rather than to rely on the secondary obligations. So obviously, if we accept the factual argument that the harm is irreparable, so any true commitment to the priority of preserving property rights should lead us or should support filtering obligations. Then when we look at the interim injunctions, and I should have added also the concept of the choice at the end of the process between injunction and damages in lieu of damages, as in the case of nuisance. So we could have, I think, useful insights. So I mentioned earlier, the difference between privacy law and which is based on balance of convenience, so whether you are likely to succeed in trial, and then you could get interim injunction, and the Bonard and Perryman rule that says that in defamation you won't get unless it's clear that you have no defense. So again, it makes sense that this private law distinction would be replicated in the way that we regulate and our expectations from the platforms. But also when we look at the law of nuisance, so at least in the UK, there is a relatively recent shift from the classic rule that the default is to get an injunction with only narrow exception of damages in lieu of injunction. So in the Supreme Court of Coventry, there's some shift that says, we will tend more easily to give damages instead of injunction. And then I argue in the book that even if this is a welcome development in the law of nuisance, which for me it's an open question, this doesn't mean that we shouldn't provide an injunction and the equivalent regulation in cases of sexual privacy, because there's a list of differences, in the interest of quiet enjoyment of land obviously has some dignitary aspect, but less so than privacy. Damages in nuisance can undo the damage, to a larger extent than in cases of privacy and sexual privacy. The distributive aspect, of power gaps is supporting more an injunction and regulation in the cases of sexual privacy than in the case of nuisance. In the case of nuisance, we have the problem of strategic behavior, and sunk costs. After you, construct a building, the injunction would be to remove it. We don't have this to nearly the same extent in cases of NCII. And in cases of nuisance, there is a genuine public interest, for example, employment of employees that, does not exist in the cases of platforms, and viewers. So, moreover, there are also cases in tort law that courts could give anticipatory injunctions, quite timid. And when you look at the case law, so you see that the irreversibility of harm is an important factor in deciding whether to give it or not. So in cases that even interim injunction and damages at the end of the litigation are not an appropriate remedy, and there's a high enough likelihood that it would happen, so courts could give anticipatory injunctions, mainly in torts protecting property. So the argument here is that on both sides of the equation, there's a good case for filtering. Why? Because we already established that the harm is irreparable, but when we think of the problem of revenge porn, as it's colloquially called, when we think of it as a problem of mass torts, so we see that the incidence that it will happen if you won't impose filtering duty is almost certain. Okay, so while for any individual woman or man, the chance is relatively low. When you look at it collectively, you see that this is bound to happen. So therefore, we could view an obligation to actively filter as the equivalent of the amalgam of potential quote timid claims by potential victims, and this could justify it. Then I also discussed the fact that the harm is gendered and, if you like, systemically gendered as an independent justification for the exceptional response. So I explained in the book, the many aspects why the phenomena, the perpetration, and the harm are gendered. And I also, again, tying it with the case for exceptionalism, I mentioned, the legal realist theme, that is associated mainly with the work of Carl Welling, that we need to work with narrow enough categories. So I'm saying, there might be other areas of privacy and perhaps even of sexual privacy in which the gender aspect is different. So in England, there used to be a relatively long list of kiss and tell cases. Many times, a footballer having a fling with a woman, and she wants to sell the story to the media. He objects. So there are, many cases, that he could get an injunction. So in this case, perhaps the gendered aspects are different, but in the cases of non-consensual intimate images, there's a clear, regressive gendered pattern that should be taken into account. And this is obviously point of difference in cases of defamation that are not related, to sexual privacy, in which it's harder to find gender aspect, but also, general distributive distinction, between claimants and plaintiffs. While in copyright, due to the the way that the industry works. So usually it's the claimant, it's the giant corporation that was assigned the rights, and it goes after the viewers, or not viewers, but those who share the copyrighted material. So in this case, distributive analysis would go in actually perhaps in the opposite direction. The next point that I would like to discuss, I already mentioned, so I just like to dwell on it a bit more, because in the book I take a case study of Facebook, and I try to analyze from the transparency reports, what is the incidence of such cases, and perhaps ironically, the transparent report is very non-transparent, so it's hard to know how much is caught by the filters and how much is not caught and being taken down, due to requests. So it's really hard to know, whether if someone would adopt my approach, whether it's economically threatening for the viability of Facebook. And in general, I argue, and this is I think I mentioned it, is the point 3 here. So when I leave size aside, so even the core case, for the big platforms, I take a Keynesian or a Calabresian approach that if the enterprise cannot bear the costs, of its activity, so we're better off that it would not exist. So I'm saying, first, it's not clear that if my approach would be adopted, so Facebook will have to be liquidated. But if it's the case, so perhaps that's the right decision because the harm is significant. And if they can't pay their costs, so perhaps this business model shouldn't work. So this is the general argument. And then I'm also relating to the question, what about, smaller platforms? Not everyone has, Facebook, Google, and, so on. And there's lots of pro-competition arguments against regulation. So this was seen a lot in the copyright area. I know that it's very costly to develop filters, and if we impose such a duty, so only the incumbents, the existing giants could survive, and therefore it's a reason against regulation. So it appears both in the literature and in policy documents. So both with respect in the EU to the DSM directive and in the UK with the online harm white paper that later became the online safety bill that still hasn't passed. So when you look at the documents, you see that there is allowance, from the reach of the platform, whether it's new, how many subscribers or users are there. So there are reduced or exemptions from obligations if your means are smaller, if your reach is smaller. So what I'm arguing both in chapter 3 and then I think also in chapter 7 is that taking the means into account is problematic, and this is, mind you, coming from me that in my first book I said the standard of care should take into account the means of both of defendants and potential victims, which again is not how the common law system works, with the exception of affirmative duties. When you don't impose the risk yourself, so then we take into account your means in deciding whether you need to, remove the risk or not. So we have it both in occupiers of land and in nuisance. And there's also some distinction in defamation. So the first point that I make in this context is that private law analogies do not support taking into account means, because again, they're based on the logic of affirmative duties. You know, you're a good Samaritan. You know, the platform is a good Samaritan. They didn't create the risk, so if you want them to do something, we should take into account the risk. But this is not the case, because they create the harm, they magnify it many times more, and also they do it for profit. So in such cases in private law, you know, we don't have the limitation that you are under duty only if it's based on your means. So that's the first point. The second point, lots of the policy discussion is very clear in the context of the UK online harm or online safety bill, talks about, you know, a proportionate approach. But and this is the fourth point here in the slide. But I argue that proportionate approach should compare victims and defendants, not smaller with bigger defendants. So if you really care about the relative power and the means of the parties, so clearly you should support such kind of obligation and not say that smaller platforms should be exempt. And then the last point, which is the fifth point here, I'm saying that even when you take into account reach, we should understand that there's a different relevance to reach in cases of, for example, copyright violations and in cases of sexual privacy. Because in cases of copyright, the harm or the damage seems to be linear to the number of viewers. You know, the more view it, you know, the bigger the damage. This is not how it works in cases of sexual privacy. It doesn't work so in general because again, it's enough that there's a critical mass of people that would create a huge damage, and then if many more, so it wouldn't change that much. That's one point, one difference. And second, in cases of sexual privacy, you would be most affected by those who know you or are likely to know you, like current or future employers, classmates in the cases of university, teachers, partners, parents, social friends, and so on. So it's enough that they are on the same platform as you, that your damage would be very, very significant, even if the general reach of the platform is much smaller. Before I move on, just to clarify the second point in the slide. So in chapter 3, when I compare also to nuisance and to defamation. So I clarified that in defamation, the relevant analogy is the innocent dissemination defense and not publication by omission, which is some English courts err to think that this is the right comparison, like Judge Edie. And in cases of innocent dissemination, post-notice, the moment that you have noticed that it's defamatory, so you are liable, if you continue with the dissemination, and it doesn't matter your means. Yeah. So this is the right comparison, and not with publication by omission. That someone's sprays defamatory graffiti on your wall or carves it, and then the question is whether you have the obligation, to tear down the fence or to. This is different because really, you did not create the risk and you don't benefit from it, which is exactly not the case with platforms that are based on the content that's provided by users. How much time do I have?
5-10 minutes.
5-10 minutes, okay. Because I have more slides to talk, so just tell me when I stop. So, okay, this is a point that I would like to discuss. Mere viewing is breach of privacy. Okay. So again, obviously, it's less problematic if the viewer disseminates further or puts a derogatory comment. so not that they harass. So then it's not very controversial or groundbreaking to say that they should be liable. The more problematic or more controversial argument is that the mere viewing for itself should trigger liability, and even more so that the liability should be strict. So in the US, that there are 4 different types of torts. Then the 2 main ones are intrusion upon seclusion and public disclosure of private facts. And the power line was one of the triggers for me to start thinking about this project, because it came very similar, very quickly after I published my book about liability of clients, and some of the statements in Powerline seem to me to support my argument. So Powerline dealt with whether the statutory liability, so it's not a tort, it's what's called the criminal restitution in the US, whether one who viewed child pornography could be liable for the entire damage from the victim's knowledge that the image is circulating, or whether it could be apportioned. That was the issue, and there were 3 different views. The majority said yes, but for a special measure, not for the full. There was one dissent by Judge Sotomayor that said, for everything, joint and several. And there was a dissent by some conservative judges that said that since we can't apportion it according to the statute, you should be liable for what you did, so no liability whatsoever. And I thought that the majority is a bit similar to what I argued in the 2013. So in this sense, I was starting thinking about that. Now, it's not something that I cover here, and at the end, my conclusion is that the liability of viewers is direct, and it's not based or shouldn't be based on contribution to demand or something like that in this context. So Justice Sotomayor says, as part of her argument, that something similar, it's not a verbatim quote, but no one could deny that viewing child pornography is an egregious breach of privacy. We know that breach of privacy is an intentional tort, and in intentional tort, the rule is of joint and several liability, therefore it should be here as well. And interestingly, the dissenters, the other judges, disagreed with most of her analysis, but they didn't say anything about this, the point that it's also a breach of privacy. So there's some US tort scholarship of the cases before Powerline was decided by the Supreme Court that say actually it's not breach of privacy. Why? Because the relevant tort is public disclosure of private fact, and the viewer doesn't disclose it to anyone, so therefore there's no liability. Justice Sotomayor doesn't go into this kind of resolution, but in the book I argue that actually the relevant tort is intrusion upon seclusion. If you view something which is private, so you intrude on my privacy. And so if you look at the restatement second of torts, you will see that in one of the illustrations there is an example of someone that look intimate photos, including a clandestine taking of intimate photos. Okay. So obviously there is a difficulty here that the possessor, the viewer, did not take the image himself. Okay? But the argument is that both based on first principles and analogy to the criminal responsibility, at least knowing possession is or could be considered intrusive. Yeah? It's intrusive of you to look at my intimate images, at least if you know that they are intimate and I haven't authorized it. There's no conceptual problem in viewing it as intrusion. In England, we could reach a similar conclusion. So England doesn't, or at least didn't recognize an intrusion upon seclusion tort per se, and the development of the tort was more the equivalent of public disclosure of a private fact. However, in Gulati, which is a case from 2015, the court imposed liability for cases that, for instances that involved only the intrusion. So and it was based on the news of the world, the hacking scandal. So there were many claimants, and for one of them, his phone was tapped, but nothing was published, and nevertheless the court gave significant amount of damages. So we see here that the misuse of public information in England developed into a tort that protects intrusion, at least in certain context. And here, for our purposes, it was the defendant wasn't the one that himself or itself tapped but they ordered it. Yeah. So at least in these cases, there's no problem in imposing a liability for receiving private information. I acknowledge in the book that it's not the same. When I ask you to get me intimate images, it's not the same as saying that if I've seen it, received it, even though I didn't ask you to do that, that is liability, but it's still compatible. We also have the case of Douglas and Hello, the wedding of Katrina Zeta-Jones and Michael Douglas in New York, that there was a paparazzi. And there the court said in the obiter that there is fresh intrusion whenever an intimate photo in public domain is viewed by another or even by the same viewer. So there the context wasn't whether the viewer is liable, it was more about whether it falls into the public domain and the republication, but it's a clear instance in which the court says, when you put all the things together, you could say, actually, yeah, the viewer could also be liable, at least if there was intention, or if you were aware that there's no consent. Perhaps I have more stuff to cover, including the difference between privacy and confidence, but I prefer to just leave it here and open it for discussion. So, thank you.
Thank you.